Not yet. Well, I can say good morning.
We are live.
I don't have to be live to say good morning. But this is Friday, March 17th, St. Patrick's Day, 2023. And we are now taking up S91, which is a bill having to do with competency to stand trial and sanity as a defense. And our first and only witness today on this issue is Karen Barber from the Department of Mental Health. So, Karen, please go ahead. And we have some students in the room, part of the youth lobby, and I think they're from Essex High School. Is it Essex High?
Yes.
Good.
Good morning.
Good morning.
So for the record, Karen Barber, General Counsel of the Department of Mental Health. I want to first thank you for taking up this important bill and for fitting me back in today. I know you're extremely busy with crossover looming and you're probably sick of hearing from me this week. But I wanted to do a few things in testimony today. I first, after hearing some of the testimony yesterday, it became clear to me that some of the people don't completely understand how the system works. So I thought I'd provide a brief overview of how it does work and who pays for things. Then I'll give a brief background of how we got to where we are with the waitlist. And third, I'll give an overview of why DMH supports the bill, thinks it's really important. And through that, I'll respond to some of the comments made by folks who testified before me. So first, how the process works. So if there's an issue of competency or sanity, it's raised in the criminal court. DMH is not a party to these cases. We don't know when those hearings are, and we're not in attendance. We find out that an evaluation has been requested when we get a written document from the court. Otherwise, we wouldn't know what the court said because we're not there. Once we get that written communication from the court, we put the individual on our list. We arrange for the evaluation through the contracts we hold, and we pay for them, not the court. And I'm not sure why there was so much confusion around that yesterday. And I note that these evaluations that I'm talking about are different than the ones allowable under the rules of criminal procedure, which allow the prosecution or the defense to get their own evaluations, and those they do arrange and pay for. Second, some background on the backlog. So as everyone probably knows, there is a backlog for competency and sanity evaluations. Currently, there's a 1 to 4 month wait backlog for inpatient evaluations, a 1 to 4 month wait for outpatient evaluations in corrections, and about a 12-month plus wait for all other outpatient evaluations. The original backlog was a result of many issues. For years, DMH had 4 main psychiatrist evaluators and a forensic psychologist. Within the last few years, 3 of these evaluators stopped doing evaluations. Around the same time, COVID hit, and it was no longer possible to schedule in-person evaluations. And at the time, most outpatient evaluations occurred in courthouses, which also closed. So while we were able to eventually transition to doing evaluations through video conferencing, that presented its own complications in terms of trying to arrange for equipment and space for defendants to use. And this is when we really saw the backlog start to increase. With the loss of some of our long-term evaluators and the nationwide shortage of psychiatrists, we put out an RFP, but the only response we got was from a Novotel, which is a provider of remote psychiatric services. While more expensive than our traditional contractors, working with the Novotel has allowed us to utilize a system developed around virtual evaluations, and it substantially increased our capacity to perform evaluations. We have many more than 4 evaluators through the Novotel contract. I can't give you an exact number because they're always adding more. They need to be licensed in Vermont, so the process takes a while. But as a national company, they don't do evaluations just in Vermont. They do them in several states. So they have a pool of evaluators. And when they get an evaluation request, they put it out to the pool and people choose if they have time to do the evaluation. But because of some of the issues outlined below, like the lack of records, the high number of no-shows, and some ethical concerns, a Novotel often has trouble getting their evaluators to want to take our cases. And that leads into why we support the bill. So DMH and the AGO, because we have assistant attorney generals assigned to our department that do our litigation and are intimately involved in these cases, We've worked with the Judiciary, State's Attorney, and the Defender General for almost 2 years now on ways to address the backlog, beginning around April 2021 with Judge Gerson. We've continuously raised the issues outlined below and some addressed in the bill without much success, which is why we feel a legislative change is needed. Before I jump into the problems, though, I do want to note our successes. I think people often see the wait list, but don't understand the large volume of evaluations that actually do get completed. In the first 14 months of the Innovatel contract, we were able to complete 460 evaluations. Thus, we were really able to clear a lot of the backlog, and now the individuals waiting have mostly been ordered in the past year. We do, on average, about 350 evaluations a year, which is a lot of evaluations. And Innovatel has continuously told us that we're quite different from other states they work with by the sheer number of evaluations they see, and specifically around sanity. Judge Zoney didn't comment on this in his testimony, but I know he looked into this and asked some of his colleagues in other states, and it is true, our numbers are larger compared to other states. So what does this bill do? So overall, this bill proposes a change as to how evaluations are arranged and paid for, meaning that instead of evaluations being arranged by DMH and coming out of our budget, that money would instead go to the court, the state's attorneys or AGO, and the Defender General, depending on who's asking for the evaluation, and DMH would be out of it. And we are supportive of this approach. I want to be clear that this isn't at all about cost shifting, although it is the result. What this does is give more ownership and control over the evaluation process to the actual parties to the case in the court. This is absolutely not some backhanded way to stop those who need evaluations from getting them. It's the opposite. It's about giving more control to the court and the parties to do these evaluations. It doesn't at all limit who can get them. It just moves the responsibility from DMH, who has no role, to the actual parties in this case, which makes a lot more sense and is certainly more efficient. By cutting DMH out of the middle, the court and parties can assure that the right people are getting the evaluations when needed and can assure those evaluations actually happen. I'm not sure the thought process behind originally assigning this task to DMH, but I think it's important to remember that we aren't a party to these cases. Our legislative mandate is to provide treatment to people who need it. Competency and sanity are legal terms, not clinical terms. And while they can be associated with mental health, they can also be associated with many other issues like developmental and intellectual disabilities, TBI, dementia, and substance use, just to name a few. So that's why we feel like the approach of this bill overall really makes sense. And so while we are supportive, I do want to address some of the other changes in the bill that I think are important no matter who pays. And there are things, again, we've consistently raised as things we think are contributing to the backlog. So first is the access to medical records, which is addressed in Section 2. Our psychiatrists strongly feel that ethically they need the individual's relevant medical records to complete their evaluations. And one of the biggest causes of delays is their inability to get them. While some courts do order records released, other courts take the position they cannot do so without statutory language explicitly giving them that authority. And this bill does that. It gives them that language, which we think is really important. To address one of the issues raised by the Defender General and the Judiciary, while this isn't a perfect fix, and there certainly may be cases where we don't know what records are out there, a lot of times we do know there are records and we know where they are. We just can't access them without a release. Second, inpatient evaluations for misdemeanor crimes, and that's Section 3. So you heard a lot of testimony yesterday about one word of this section written, but not why the language was changed. So I first wanted to address that. So 13 VSA 4815G says that the court should not order an inpatient evaluation in misdemeanor cases unless good cause is shown. Despite this, and with no finding of good cause, inpatient evaluations are routinely a result of misdemeanor offenses. And because those evaluations are given precedence, they in turn add to the backlog. So this language adds specifying language that a court must make those findings of good cause, and to do so in writing. And why is the writing piece important? So again, you heard some testimony about this, about how written would be overly burdensome and cause delays. And again, I think this is because people just simply didn't understand how the process worked. There's no delay requiring it in writing because the only way DMH knows about the evaluations is in writing. The court already does this. We're not at these hearings, so we have no idea what the court may say on the record. We rely on that written communication, so we wouldn't know that the court has found good cause or why without it being in writing. And again, it wouldn't cause a delay because nothing happens until we get the written document from the court anyway. So we'd ask that this language remain. Third, separate.
Can I ask a question about that?
Of course.
So there's an interesting article in the Bennington Banner this morning. That's a case out of Brattleboro where a mentally ill person has continually created problems with misdemeanor behavior. And I'm sure it's true in every community. There is someone who is out of control and needs help, but hopefully not a forensic facility and hopefully not incarcerated in a correctional facility, but that seems to be where this is headed. He's been assigned to Pathways Vermont, but the judge says, I don't believe that will benefit him. Is this the type of individual you're talking about here? Obviously not knowing the case, but.
No, so this is simply focused on what kind of evaluation they're getting. And again, competency and sanity evaluations are really separate from the mental treatment needs of an individual. So someone can be hospitalized at any point if they meet that criteria. What we're really talking about is where they get an evaluation and where they go on the list, because we prioritize people who are inpatient, right? So if someone needs inpatient, if they meet that clinical level of care, then they would be given that. This is really a separate issue. It's more about those legal evaluations as opposed to mental health treatment.
Okay.
Does that make sense?
I guess, but the court, what we're really talking about here is the written findings for an inpatient evaluation of somebody who's committed a misdemeanor.
Yeah, and part of the reason why we think this separation of taking this out of DMH makes sense is because it's confusing, right? You're really confusing when people need mental health treatment and what their actual needs are versus like this legal standard of, are they competent to stand trial? Are they sane, which is an affirmative defense? You're confusing the two things, and we're trying to separate them back out because it does cause confusion.
Okay, Mr. Bianchi, the deputy state attorney in Bennington County, was pretty emphatic in that the writing wasn't needed, the written.
And it could be because he's never seen those orders. He may not realize that DMH already gets orders because they come to us. But again, we wouldn't know what the court did unless we got it in writing because we're not at the hearings. And I think it's just a misunderstanding of maybe how DMH understands.
His comment was needing to await a written order is unnecessary as the requisite findings can be made on the record if an inpatient evaluation is needed. Such delay can be harmful to everyone involved. So in other words, he believes it takes time for the court to make a written finding. And during that time, the need for the evaluation is delayed, and that can be harmful to the victims, to everyone. So I guess, why couldn't you get a copy of the findings that are on the record?
Because we don't know those cases are happening. We're not a party. So we don't go, we don't get notice of them. We have no idea that this is happening. We find out when we get something from the court that says we're requesting an evaluation. Otherwise, we wouldn't know about the cases.
Okay. So when you have a written finding, how long does it take to get the written finding, a written order?
I assume the court issues them right after the hearing. I don't know because again, we're not in court. What happens is the court sends over a request for evaluation. And once we see that request, then we put them on the list, but we don't know about them until we get the request.
I think Eric is in another committee and wasn't available, but Peggy, if you could note this for Eric to particularly focus on the written versus the finding on the record.
And I'm happy to follow up with Jared as well. Again, I think it's probably just, he just didn't probably understand how we got notice of things.
Maybe, and there may be a way to do this, make sure that the findings on the record are shared with DMH rather than having the writing.
Sure, yeah, just as long as we get some written document. I think it can just be included in the documents we already get.
Yep, okay. So
third.
I took you off your...
No worries. Separation of competency and sanity evaluations, which is addressed throughout the bill. So right now, again, almost always if a court orders a defendant to be assessed for competency and sanity, those evaluations are requested to be done at the same time. However, the consensus recommendation in the field of psychiatry is to separate the two because of the concern that an independent or an incompetent defendant can't effectively participate in an evaluation around sanity. And a lot of our Novotel evaluators take this position that ethically they can't do an adequate sanity evaluation if someone's incompetent, and that increases the backlog. There was a lot of testimony about this back in 2021. Including Dr. Simi Robin, who is the chief medical officer at Howard Center, but more importantly for this discussion, an assistant clinical professor in law and psychiatry at the Yale University School of Medicine, who often does competency and sanity evaluations. And she testified a lot about this. So this has been a problem that the department has identified for several years. And the compromise language, as Eric explained, that was passed in 2021 said that the two evaluations should be separated and sanity shouldn't be done unless the person was found incompetent, unless their attorney asked for them to be together. And since this law passed, we've seen almost no noticeable difference. Almost all are requested together. So it still remains a problem. So this time we're proposing a different solution, which is if the defendant wishes to raise sanity, they can arrange for an evaluation at any time throughout the process. This way, the ethical issue is resolved and the concerns of the defender general are also resolved. In fact, it gives much more control to the defense than the current system. Because again, I think it's important to remember that unlike competency, which is a baseline requirement for someone to go to trial, sanity is an affirmative defense. Thus, it makes sense for it to be entirely controlled by the defendant so they can manage it how they see fit, which is versus DMH, which really has no role in these cases. One of the other things I want to touch on is Section 4, which is what we call the S3 Act 57 fix, which is that same bill I was just talking about. But one of the things this bill does is fix what DMH believes was maybe an unintentional change in Act 57, which changed the requirement in 13 BSA 4816C1 from an or to an and contributed to the backlog. So this is a section that deals with the requirement of having a psychologist examine a defendant thought to have a developmental disability. So before this change, the language stated that a psychiatrist or a psychologist would evaluate the defendant and write a report depending on the needs of the defendant, meaning if the court or defense attorney specified a developmental disability, the psychologist did the assessment and wrote the entire report without a psychiatrist. However, if in doing an exam, the psychologist suspected a co-occurring mental illness, a psychiatrist would be involved, and same for the reverse. If a mental illness was alleged, a psychiatrist did an exam and was concerned, they would then ask for a psychologist to come in. But the language change from an or to an and now technically requires both professionals review, even only when mental illness or developmental disability is thought to be present, which contributes to the backlog because it requires unnecessary evaluations. And it is one of the issues we discussed back in April 2021 with the AGO, state's attorney, judiciary, and defender general. And at that time, everyone agreed that the amended language didn't make sense, that there was no reason to have a psychiatrist examine someone who has a developmental disability, as it's a waste of time and resources and unnecessarily contributes to the backlog. So everyone agreed that DMH would continue to follow the process that we had been doing pursuant to the language change. However, we have been noticing lately that courts have been interpreting the statute as requiring them to have both evaluations. So to fix this, we're asking that we revert to the old language. Now, some of this is tied to a suggestion by the Defender General yesterday, which was to allow forensic psychologists to do these evaluations. And we're open to that suggestion, but we think there should be more discussion before the language is changed, just to make sure there's not any unintended consequences. I did speak quickly to Dr. Robin about this issue, and the legislature may want to hear from her directly, but basically she had two things she thought of initially. One, it's fairly rare that psychological testing is actually needed in competency evaluations. She noted that she's done lots of competency evaluations and supervised many more, and she couldn't think of one instance where she thought she needed psychological testing in order to reach an opinion. The second one is that one of the things that's lost with the psychologist only is that medical background, and an evaluation of medical and organic illnesses that could impair someone's competency to stand trial does come up quite often. So for instance, thyroid disease or the effects of a corticosteroid medication, those things can impair cognition and mental status, which impact competency. So for now, we'd ask the language in the current bill remain, and we think about, again, we're open to it. We just want to make sure we're exploring it more to make sure there's not any unintended consequences. The bill also—
So you would oppose the term examiners?
Yes.
Was the change suggested yesterday?
Yes, we would.
Okay.
So this bill also attempts to address the very large number of evaluation requests we get, which I noted is higher than other states. And one of the ways it does this is the language in Section 3, which requires an actual factual basis to be presented to the court, and we support that. It also attempts to deal with no-shows, which, as I explained before, is a large issue for us. And I think you noted it yesterday, Senator Sears. So our evaluators often set aside several hours to do these, not just to see the defendant, but to write the evaluation report. And so when there's a no-show, all of that time is lost. And rescheduling means that someone gets pushed further down the wait list. So by moving the responsibility to the individuals who are actually parties to the case, it would help, instead of putting DMH in the middle, trying to coordinate with parties in a case we're not a part of and with people we don't know. We think it's much more efficient, and again, gives more control to the court and the parties of these cases. Again, these are legal issues, not mental health issues. And finally, Section 7, which is the Competency Restoration Program Plan. This was a topic at the Forensic Work Group and one which we didn't reach consensus on. However, we do feel it's worth exploring further and think asking DMH and Dale to work together on a proposal is a good next step. While there is some disagreement, both forensic psychiatrists who were part of the work group, Dr. Robin and Dr. Bolton, both strongly supported this concept, and it may be worth hearing from them before any changes are contemplated. I'd also note that as written, this doesn't create a competency restoration program. It just calls for a plan to be proposed to the legislature so you have more information to make your final decision. So in conclusion, DMH believes this bill is really important for all the reasons I listed today, and we look forward to working with Leg Council on the next draft. And I'm happy to answer any questions.
Yeah. Did get an email from Kelly regarding this.
Ms. Carroll?
Yes, Kelly Carroll, thank you.
Yes, it was
She
in the
said
forensic
that
work group.
the committee should reach out to Dr. Simha Raven.
Yes, Dr. Robin. Yep.
That's Dr. Okay. That's the
Yes.
same one you're suggesting.
Yes, they gave a whole presentation at the forensic work group, and I do think that too, both Kelly and Joanne were very supportive of their proposal. And in the forensic working group report, which we submitted in January, I believe, it does include the report by Dr. Robin, or the presentation by Dr. Robin and Dr. Bolton. So that is something you guys could also look at.
Okay. Peggy, I'm going to forward you a copy of for presentation. And then you could perhaps contact her to see if she's available next week to testify.
Will do.
Senator Wachowski.
Thank you. Thank you, Karen. Is there a notification system for people who have been scheduled for these evaluations?
So let me answer and see if this answers your question.
Okay.
So when we arrange for an evaluation, we reach out to the defense attorney and say, we have this time and date available for, will this work for your client? Then they go back, talk to their client, they come back, tell us yes. So then we reach back out to a Novotel and confirm. And then before we send reminders before the evaluations to try to ward off no-shows. So we will remind defense attorneys and ask that they confirm with their clients when we get close to the actual evaluation.
But there's no system set up that's directly, we're sort of relying on a middle person. There's no, text reminder that goes directly to the client. There's no.
No, well, I don't know how it works, how people communicate with their client, but we, again, as we're not a party, we can't reach out and talk directly to the defendant. So we are like a middleman, which is part of why we think taking us out of the middle and putting it in control of those parties actually would be more efficient, because that is part of it, right? We're trying to deal on both ends and make these connections.
Thank you.
Other questions of Karen regarding yeah, it's unfortunate that the study committee couldn't come up with a recommendation in terms of competency restoration, but just a quick review of the slide presentation does indicate some interest there, but it kind of there are some individuals who could not regain competency, correct?
Correct.
For example,
Yes.
Somebody with dementia, it's not going to get better. Somebody with a traumatic brain injury, probably not going to get better. So, okay. I think I have a pretty good idea of where you're at on this, where the department is, I guess, somehow working out would be helpful if you and the state's attorneys and defense defender general could work out the issue of written findings and so forth before we come back to this next week.
Certainly.
If there's a way to make sure you get the on the record findings. I hate to do anything that further delays. And I guess I remain a little confused on the difference between the psychologist and the psychiatrist in terms of your view, or the Department of Mental Health view, I should say, regarding keeping those two separate.
So I think overall our concern is that unless there's a reason to have two individuals do an assessment, we don't want them done in every case just because the statute says and. We want to make sure that clinically it's necessary to have two different individuals with two different skill sets actually evaluate a person. Because our concern always is, how do we move people along and how do we do these evaluations in the quickest, most efficient way? And if we're doing evaluations that don't need to be done just because it says you need both, it seems really inefficient to us. But certainly if there is a reason to do both, some of that might be addressed. If a psychologist can do both reports, we just, at this time, we don't have, we just don't feel like we have enough information to say one way or another, whether that makes sense to us. We just want to make sure we're talking to clinical folks that have the expertise in these matters for them to weigh in, because we just want to make sure whatever happens doesn't have unintended consequences.
Yeah.
Does that answer your question?
Yeah, to some extent. I'm still worried about the doctorate level psychologists obviously are not psychiatrists, but they certainly, I think we give too much sometimes to title and the competency of I'm using the term competency in a different way. It's who's competent to do the evaluation to determine whether somebody is competent to stand trial. And, I think there's probably many psychologists and psychiatric social workers, for that matter, who are just as capable as any psychiatrist in making those decisions. Maybe that's just my own personal bias.
I'm just a lawyer, so I defer to the
Understood.
medical professionals on that one.
Okay, thank you. Any other questions for Karen before we adjourn for the day and the week? Good job, committee, on a lot of bills this week and this session too. So we've gotten a lot out. We have 2 left to go. And I'm not sure how hospital liens will go or S91, but hopefully we'll kick those out next week. Have a good weekend.
You too. Congrats on a successful